Okay. So welcome, everyone. I'm absolutely delighted to see such a full house for the 19th annual Valerie Gordon Human Rights Lecture. For those who don't know me, my name is Jeremy Paul. I'm the relatively new dean here at Northeastern, and I am absolutely thrilled to be involved in this wonderful day. Let me start with a few thank yous. First and foremost, I'd like to thank our guest, Dr. Philip Alston, who has come today to speak with us. You'll hear more about his background from my colleague, Professor Hope Lewis, who will introduce him in just a moment. I'd also like to thank the family of Valerie Gordon for having been so supportive of this lecture for so many years, and to welcome, unfortunately, only by phone. We're sorry, Ms. Cozy-Pooley, about your train issues, but we're delighted that you can be here by phone to listen to this lecture, and we appreciate all your support over many years. I'd also like to thank Kevin Murray, Mariah McGill, Martha Davis, and Hope Lewis for their spirited leadership of the program on human rights in the global economy that is so closely connected to the Valerie Gordon lecture. So I like to say, I've been telling people about my arrival at Northeastern that it's like buying a new house, and every time you go around the corner, you see something beautiful and new that you didn't know you had before, and you're just thrilled, a new fireplace or so forth. And this lecture certainly fit that bill for me when I began to read about it. Past lectures have included a virtual who's who of people who have made major contributions to the human rights community. Some names I'm sure you would know: Dean Harold Koh of Yale Law School and longtime legal advisor to the State Department, Albie Sachs from the Constitutional Court of South Africa, Charles Ogletree, professor at Harvard Law School, Judge Cepeda from the Constitutional Court of Columbia. So you can see not only is it a who's who, it's also an international who's who. And what our expectation is that in the future, anyone in the human rights community will be immediately established by being able to say that they gave the Valerie Gordon Human Rights Lecture. Let me also say, again, thank you to the people who got this going, that this sort of lecture serves exactly the purpose that one hopes that it would, in keeping alive the memory of such an important contributor to the Northeastern community as Valerie Gordon clearly was. Were it not for this lecture, I probably would not have had the opportunity to read about her many contributions. I heard she was described as wickedly smart, although now given that Northeastern has been called wicked awesome, maybe it should just be wicked smart. But in any event, she clearly played a major role in contributing to the law school's founding of the program on human rights and global economy, to helping us to recruit faculty members of color. I'm told that she was a person of strong views, not afraid to express them, and we're very glad that she, in fact, did so. And so it's wonderful to have an opportunity to revive her memory as part of this lecture series. Now, without further ado, I'd like to introduce my colleague, Hope Lewis, who's been on the faculty here for many years. She's a legal scholar and human rights advocate. She's a professor of law, chair of the Global Law Committee, and founder of the program on human rights in the global economy at Northeastern. She serves on numerous law school committees. She's the recipient of the ABA Section on International Law Meyer Rasmussen Award for Mentorship of Women, recipient of the 2011 Thomas J. Carroll Award from the Carroll Center for the Blind, and also the 2001 Hayward Burns Shanna Gilbert Award from the Northeast Regional People of Color. She's also a fantastic person, someone who I've been very thrilled to get to come to know since I've been here, and she will have the privilege of introducing Dr. Alston. So thank you again all for being here. I look forward to an interesting lecture.
All right, so first let me thank Dean Paul for that wonderful introduction to the introducer. I also have people to thank, so I would like to thank Kevin Murray and all of the organizers from Fergie who invited me to do this, to have this honor, Balsa, who co-sponsors this event, and I'd also like to recognize Mrs. Pulley, who is on the phone, and the members of Valerie Gordon's family, who for the past 20 years have been coming and otherwise supporting this important event. I have a special word of thanks to Christina Alexis Clark, because that beautiful photo of Valerie Gordon just stunned me and brought me to tears. She was a wonderful and dynamic person, and one of the reasons that many of us were able to join this faculty. She was active in something called the Student of Color Coalition, as well as BALSA and other organizations, an advocate for the end to apartheid in South Africa, and an advocate for civil rights in the United States as well. I'd finally like to congratulate Ms. Mayumi Grigsby, who is the recipient of this year's Spirit of Valerie Gordon Book Award from BALSA, which will be presented following our distinguished lecturer today. Philip Alston is the John Norton Pomeroy Professor of Law at New York University Law School. And for the past 20 years, as you've heard, Northeastern has hosted a series of legal advocates and scholars who have worked to change the world. Like Valerie Gordon and our students and alumni, they inspire us to speak truth to power in the name of human rights, dignity, and social justice. Philip Alston is such a person. Professor Alston co-authored the leading international human rights textbook, International Human Rights, Law, Politics, and Morals, which I believe is in its 4th edition. His distinguished and varied career demonstrates that human rights, all human rights, civil, political, economic, social, and cultural, are indivisible, interrelated, and interdependent. A former chair of the UN Committee on Economic, Social, and Cultural Rights in its formative years, he has led efforts to provide thorough and rigorous support to add meaning and reality to what had previously been marginalized and aspirational goals with regard to economic and social rights. What could it actually mean to require states to recognize and implement education, housing, health, food, clean water, decent wages and working conditions, and the right to cultural participation as human rights and not just charity? More recently, Professor Alston served as the UN Special Rapporteur on extrajudicial summary or arbitrary executions. And in that role, he took powerful governments, such as our own, to task for targeted or arbitrary killings and the indiscriminate or otherwise unlawful use of drones. Professor Alston's work as Special Rapporteur has taken him to various hotspots around the world, such as Sri Lanka, Nigeria, the Democratic Republic of the Congo, the Philippines, Israel, Lebanon, Kenya, Central African Republic, Albania, Afghanistan, and that most, troublesome hotspot, the United States. Philip Alston has devoted his energies to building awareness and action in support of the universal nature of international human rights. A committed teacher and renowned scholar, he has taught at numerous prestigious legal institutions throughout Australia, Europe, and the United States. Professor Alston also co-chairs the Center for Human Rights and Global Justice at NYU. It is a particular pleasure and honor to welcome him as Northeastern's 2013 Valerie Gordon Human Rights Lecturer. Welcome.
Well, thank you very much, Hope, for those very kind words. It is a very great pleasure to be here. I'm astounded by the size of the audience, I have to say. One never knows when one gives a lecture of this kind what sort of audience will be attracted because of the somewhat esoteric nature of the topic. I wasn't planning to say this, but I have a vivid recollection, just by contrast, of having been part of a panel at the American Society of International Law a number of years ago, which featured Father Robert Drinan, who will be known to many of you, the Executive Director of UNICEF, James Grant, who was a great personality in his own right, and me. And we turned up to this auditorium, and it turned out that the, in brackets, dreaded Alan Dershowitz was making a pronouncement on torture warrants at the same time in another room, and we had 3 people in the audience. I should add that 2 of them were staff members of James Grant. So I'm very grateful to you for all being here. So we're talking today, or I'm talking today, about social rights. I have taught in the United States off and on since 1984. And it's a very schizophrenic experience because when I'm not in the United States, I can speak to colleagues and audiences and so on as though they understand and instinctively support the notion of social rights. As soon as I come back to the US, which is home these days despite my accent, immediately I'm on the defensive. I know that most of my colleagues would look at me if I were to talk to them in the faculty lounge and say, social rights? You mean partying and things like that, or what? Or if I were to talk about economic rights, Richard Epstein or someone else would greet me and say, you're absolutely right, Philip, nothing more important. The right to contract and the right to property, economic rights are central. But here, of course, given the incredible record of Northeastern in this area, the work done by so many of your faculty members who have really contributed at the cutting edge to work on social rights, I'm assuming I don't need to say this is what these rights are. There is something like a right to housing, a right to food, and a right to education as part of any defensible package of human rights. The idea that we are looking at fundamentals that are necessary to fulfill the human dignity of individuals and can exclude those elements is, to me, unthinkable and unimaginable. But, as I said, it's where so often the debate must begin in groups that tend to start from much more libertarian premises. But I'm simply going to scoot over all of that today. The focus is on this strange body, the United Nations. I'm going to speak to some extent about the UN itself, but also more broadly around it. The UN happens to be the context in which a lot of the efforts to promote the notion of economic and social rights have taken place. But so too that applies to all human rights. While the United States and many others were at the forefront of promoting notions of human rights for many decades, it was only when the UN finally embraced these at the behest of the US in 1945 and began to elaborate the Universal Declaration of Human Rights in 1948 and so on, that there was a real international movement to give some sort of impetus to the notion of human rights. And so it's not surprising then that the effort to give an impetus to the notion of economic and social rights also came from and focused much on the UN context for many years and still does, although, as I will suggest, it does so to too great an extent today. Going to the UN then, institutions are very important in the human rights area, as we know. We're seeing that today, yesterday. US Supreme Court, gay marriage, institutions are where it's at. You can declare human rights, you can proclaim them, but they are always going to be either adjudicated or given content and meaning by institutions. So the big challenge in the UN context is to set up some sort of institutional mechanism to provide some momentum. The UN recognized that immediately in relation to civil and political rights, and so a so-called Human Rights Committee was set up right at the outset. As soon as the two covenants entered into force, the Human Rights Committee began work in 1977. It was another 10 years before an independent expert committee to focus on these rights, economic and social rights, was set up. So it's only since 1987 that the UN has had a sustained institutional involvement in these issues. The work of that committee has been, I think, very effective by its own standards. Now, this is a technical set of issues that would be of more interest to international lawyers, and I'm not going to bore the rest of you with it right now. The mechanisms, the techniques that were available to this committee have been used reasonably effectively. In brief, those mechanisms are the so-called reporting mechanism, whereby states have to report every 5 years, roughly, on their compliance with the International Treaty on Economic and Social Rights. Now, committees can make that exercise more or less meaningful. In the case of the United States, which of course is not a party to the Economic and Social Rights Covenant, the US has taken very seriously its reporting under the other covenant, and its 5-yearly reports, Harold Coe, if he were here, would tell you had caused him many a headache and lots of time spent reporting to the UN and trying to persuade it that in a whole range of areas the US was in conformity. I think this UN Committee on Economic, Social and Cultural Rights has succeeded in making that reporting procedure meaningful in relation to a fairly significant range of countries around the world. More importantly, in a way, although I'm not going to talk about it in any detail here, is the development of a strange technique which most lawyers would be very puzzled by, I think, the adoption of what the UN calls general comments. These general comments are not quite papal encyclicals, if I can use a Catholic analogy, but they are the committee's own distillation of its jurisprudence on a particular issue. So the committee looks at an issue, whether it's the definition of a right or the nature of obligations or whatever, and says this is how we understand it. Now, those general comments have no particular legal status. The only status they have is that of being able to represent the views that the committee itself considers to be authoritative, and if they are persuasive, if they are compelling in their own right, they can have a very big impact. And in some cases they have. I'll come back to that briefly later on. In addition to those two efforts, the UN Committee has, I think, succeeded in involving non-governmental organisations much more broadly in social rights. It's provided some sort of central focus for efforts in this area, and generally, by the standards of its peers, would be considered to have done an effective job. But, as I said, let me come back to it and make the counter-argument in a moment. Second area in which the UN has taken action to promote social rights is through the so-called Special Rapporteur system. Hope mentioned before that I was Special Rapporteur dealing with extrajudicial executions, and that mandate was in fact the second one set up by the UN back in 1982. But again, it wasn't until 1998 that the UN first set up a special procedure dealing with economic and social rights. So there had been 11 consecutive mandates dealing with issues of civil and political rights before there was a single one on economic and social rights, thus emphasizing the reluctance of states, and in part, of course, the reluctance of the United States, which I'll come back to briefly again in a moment. Today there are a significant number of these special rapporteurs on subjects like the right to food, the right to health, the right to housing, the right to water and sanitation, cultural rights, right to a healthy environment, and so on. Those rapporteurs are doing a good job in many respects. Again, I'm not here to talk to you about that full gamut of activities, but certainly a number of them have contributed in very important ways. I would single out just one easy example in a way. It's worth mentioning in this audience. The right to water and sanitation. Some of it's very interesting reflection on the international system. Some of you will know that there is no right to water and sanitation. Well, excuse me while I pay tribute. It's not mentioned in any of the international documents, but there was a movement that began and was crystallized, in fact, by the UN Committee adopting a general comment saying that there is a right to water, that this can reasonably be derived from several other rights, whether it's the right to health, whether it's the right to an adequate standard of living, whether it's a right to human dignity or whatever. A number of governments reacted very, very negatively. This was completely unacceptable. I still remember the good old days when the United States government made a point in the UNICEF context, because I did a lot of work for UNICEF. Every time anyone said something like, well, of course, children have a right to water, the United States government would make very good use of our taxpayer dollars by stepping up and saying, Mr. Chairman, we want to make absolutely clear that there is no such thing as a right to water. Mind you, we are not opposed to water. We think it's a very good thing, and everyone should have it, and we really want to make an effort to bring that about. But it's not a matter of rights. And of course, sanitation, also a much neglected area. The right to a toilet, if you want to reduce it to that. A very, very, very fundamental right, as any of us will know who have been in situations where there are no such things. As a student, I spent 2 months in Papua New Guinea in a very isolated area, defecating, etc., on the beach early each morning, and one gets a very good sense of the importance that, and that was fine because the beach was big enough, the ocean was strong enough, that things were taken care of. But there are a great many areas where that is not the case, and the absence of sanitation facilities is dramatic. But in any event, the good news is that the combined work of the UN Committee and then the appointment of a special rapporteur, a particularly effective Portuguese expert, has resulted in the fact that now the United States, Canada, believe it or not, a firm opponent, also Germany, have all come around. And they all say, okay, there is a goddamn right to water if you really insist. This is a big breakthrough in a whole range of ways that I would be happy to talk about at some point. In addition, two other things that I would mention and then try to move on. There is now an individual complaints system at the international level for economic and social rights. This is something that has long existed for other human rights. It's, of course, not applicable to the United States. Never will be, don't fear. The US has a long, deep ingrained resistance to any sort of international mechanisms of that sort. But there are hundreds, literally, of other countries around the world that have accepted such complaints arrangements in relation to civil and political rights. And now this new mechanism for economic and social rights has entered into force at the international level. So, again, it's a significant achievement. I had other things that I wanted to mention, but I want to move on to get to the crux of what I want to talk about. So let me move briefly backwards to the shortcomings of what has been achieved so far in the UN context. The work of UN committees, such as the Committee on Economic, Social and Cultural Rights, is very hard to evaluate. It's particularly hard for someone like me. I spent 12 years of my life sitting in miserable conference rooms in the UN as part of this committee, 4 years as its rapporteur, and the following 8 years as its chairperson, at the end of which I said, I'm out of here, I can't bear it anymore. 12 years is enough. The reason is that these international committees, like almost any committee, I guess, I've never been associated with a congressional committee, but I'm sure there are a lot of congressional committees whose work is not of the nature that we read about excitedly in the newspaper when major big-time hearings are held. There's a lot of routine, rather tedious stuff that goes on, and UN committees are very tedious and routine in their day-to-day work on examining reports by governments and so on. It has to be said that the work of this committee, like that of its peers, like the Committee on the Elimination of Discrimination Against Women, Committee on the Rights of the Child, has achieved an awful lot when viewed from within a narrow perspective. Those who are actually involved in it, those who can take some of the outputs and turn them into something more practical. But it has to be said that when you step back and you look at it in the grander scheme of things, the impact of some of these committees is radically more limited than one would like. They have not really seized the agenda. They have not breathed great life into areas where there hasn't been much before, and many of their achievements are fairly self-referential in a sense. Again, these are parts of bigger issues, but I think the UN Committee could have achieved a lot more than it has to date. The special rapporteurs I mentioned before, there have been some brilliant achievements. I exemplify that with the right to water and sanitation. A number of others, the special rapporteur on the right to food has been very active now over a number of years and has made a big impact in different areas. But as a group, these special rapporteurs have made only a limited contribution to really enabling a clearer vision or understanding of what it means to recognize economic and social rights internationally. Finally, there is a topic that only specialists will have heard of, and I want to mention it mainly for them. This is the odd topic of the right to development, something that was championed by developing countries in the UN context back in the mid-1970s. The right to development is a very odd character, very odd beast. It has instinctive appeal. It has been taken up by a number of states who will say, well, of course there's a right to development, and we exercise it on behalf of our people, at which point a red flashing light should come on, because any state exercising a right on behalf of its people is unlikely to do the right thing with it. This in turn has led to great resistance by many states, including the US and its Western allies, saying we are rather dubious about this, but the right is not so patently problematic that it can be opposed outright. And so the US, like others, have sort of gone along with discussions about the right to development. The problem is that because it has been afflicted by a comprehensive stalemate at the international level for, 35 years now, it has sucked a lot of the energy and oxygen out of the broader debate that there should have been around international obligations in relation to the promotion of economic and social rights. And that, I think, has been most unfortunate. What I want to do in the lecture, which you'll be pleased to hear is not all that much longer, is to look at some of the future directions that I think should be taken in terms of promoting social rights at the international level. But I can't help just a brief word about the United States. Some of you will know this well, but the US has a very checkered relationship to economic and social rights. In a nutshell, many opponents of these rights think that they are creations of communist states that were foisted upon the international community by the Soviet Union and others. In fact, their origins can be traced very directly back to a much better known communist by the name of Franklin Delano Roosevelt. Roosevelt's proposal for a second Bill of Rights led very directly to another well-known communist group, the American Law Institute, believe it or not, putting forward a statement of essential rights back in 1945. And this statement of essential rights actually includes virtually all of the economic, social and cultural rights which were subsequently adopted in the Universal Declaration. And the wording that is adopted in the Universal Declaration bears a far closer resemblance to the statement of the American Law Institute than any other formulation ever put forward. The United States for a number of years was either supportive or agnostic about these rights, except to the extent that, of course, they were championed by the socialist countries, by the communist countries, which then led us in the West to make the mirror image argument that the communists made. The communists said if we can only satisfy economic and social rights, other rights will take care of themselves, freedom, liberty, etc. We said the opposite. If we can only get civil and political rights, a free people will inevitably enjoy economic and social rights. Now, of course, both arguments are equally uncompelling. We have not succeeded in automatically realizing economic and social rights, despite achieving a very high level of freedom and liberty. It doesn't follow. Nonetheless, Jimmy Carter signed the Economic and Social Rights Covenant. Ronald Reagan made a major point, and particularly his Assistant Secretary of State, Elliott Abrams, well known in a variety of other contexts, including Iran-Contra, of denouncing these rights, saying that they were not rights, that they were highly problematic for the whole notion of rights, and the US would have nothing to do with them. Clinton came in, announced for the first few months of his presidency that the US was changed, that he was going to take a very positive attitude towards these rights, and then gradually backed off, so that by the end of the administration there had been no serious action on these rights. And so it remained, of course, under George W. Bush. About halfway through the Obama first term, the Assistant Secretary, Michael Posner, announced a big new policy that the US was going to now be not opposed to economic and social rights, and that it would be supportive whenever it can. But I just want to give you a sense, I'm sorry I'll waste a minute of your time, even two, of how that translates and how enthusiastic the United States is today about economic and social rights. This is a statement that was made, I think, last week. If it wasn't last week, it would have been the week before. And it's in relation to a resolution which was entitled "The Right of the Child to the Enjoyment of the Highest Attainable Standard of Health." That's the UN jargon for the right to health. The United States remains deeply engaged in promoting healthy children, both domestically and internationally. We look forward to continuing to work with other nations and international partners to ensure that all children, blah, blah, blah. And I'm skipping over only about half a page here. Today, we co-sponsor this resolution with the express understanding that it does not imply that states must become parties to instruments to which they are not a party, or implement obligations under human rights instruments to which they are not a party. Furthermore, to the extent that it is implied in this resolution, the United States does not recognize the creation of any rights or principles that we have not previously recognized, the expansion of the content or coverage of existing rights or principles, or any other change in the current state of treaty or customary international law. Further, we understand the resolution's reaffirmation of prior documents to apply to those who affirmed them initially. We read this resolution's references to the right to safe drinking water, etc., in accordance with our September 27, 2012 statement in Geneva and our July 27, 2011 statement in New York, etc. So it's sort of like one of those drug advertisements. You know, you've got to read all the fine print at the end, which, having told you that it will certainly cure your ailment, then announces that it may, however, cause heart failure, total congestion, constipation, and 18 other things. So the US remains extraordinarily ambivalent in all of this, and has continued then to be something of a drag on real international efforts to move forward on economic and social rights. So let me focus then on what I think the future direction should be, what the UN could do, what other actors can do in that context to make a reality of these rights. First of all, and this is really again for the initiated, I guess, one of the things that is most surprising in this particular area is that academics and UN committees and so on have been obsessed with coming up with typologies and acronyms and so on, which they seem to think will resolve the deeper underlying problems. So you've got, well, there's the respect, protect and fulfill trilogy, which is useful but has its limits. There is the 4 A's that the committee has applied in its analysis of all rights. I don't even remember what the 4 A's are, I have to admit. I think they are availability, accessibility, acceptability and affordability, but I may be wrong. And every right is analysed according to those 4 A's. It's pretty silly stuff, to be honest. There's a framework that the committee has come up with called IBSA, which is indicators, benchmarks, scoping and assessment. There is a thing that the Centre for Economic and Social Rights, with which I've long been associated, has come up with called OPERA. It's not Opera Winfrey. It's Outcome, Policy Efforts, Resources and Assessment, and so on. And the assumption is that if you've got enough of these fancy typologies and so on, you can finally find out what economic and social rights are and come up with a recipe for their promotion. But there's been a lot more effort put into devising those than there has been to actually try to be really effective in this area. My second comment is again a negative one, and this is problematic, I acknowledge, because it's a critique of much of what I have been involved in over the years as well. The involvement of international lawyers in this area has brought its own problems, and lawyers in general. Two ways in particular. One, there has in some ways been an excessive focus on the international machinery, the sort of stuff that I started my talk describing, sort of stuff that I was heavily involved in. It can produce dividends, but they are limited, and it's not where the main focus should be. The other area, which has become almost dominant in recent years, is the response by proponents of economic and social rights to the main critique that has been levelled at them. The standard American response to economic and social rights is, can I get them into court? Are they justiciable? And if they're not really rights. They're something else, but they ain't rights. I can tell you that. Leaving aside the fact that the argument is highly contestable, and particularly so in other societies, leaving aside the fact that, as Martha Davis and others have shown, there are many rights that can be adjudicated even in the US legal system, many social rights. Leaving those facts aside, scholars in particular have made an enormous effort to try to show that economic and social rights are justiciable, can be dealt with effectively by courts. There have been some excellent books written. My colleague Katie Young has just produced a book on the, what's it called, the constitutionalization of, it's not quite the right word, of social rights. It's an excellent book. Jeff King has written a whole book on judging social rights. Mark Tushnet from Harvard has done a lot of work on the role of courts in relation to economic and social rights. I could name many other books. This is a flavor of the month, if you like. I want to suggest that, in fact, the prospects for judicial enforcement of social rights around the world is actually very limited. I'm not saying it's not an important area. I applaud those who work at trying to get US courts to take these rights seriously. But it's going to be a long and slow road. It's an important one to explore. It's going to be even longer and even slower in most other states. And the books that celebrate the justiciability end up focusing on a handful of countries. There's no question that my heart has been blessed. The handful of countries that have shown the way, India, South Africa, Colombia, you had Justice Manuel Cepeda here a couple of years ago, have done important work. But in Lucy Williams, for example, has pointed, I think, in very compelling terms to the limitations of what the South African Constitutional Court has done, despite the fact that it is the much celebrated example. in this area. Maybe we should part company. Thank you. Okay, at least that's a novel turn on the usual cell phone ringtone interrupting. Okay, so the argument simply is that an awful lot of energy has been devoted in recent years to this question of judicial remedies. And I think it's important, but I think it's also very important for us to recognize that this is not going to transform the situation in the years ahead, and it's not where our main energies should be. Thirdly, another negative comment, I'll get positive in a moment. Australians don't like to be too positive, though. Concerns the focus in recent years on extraterritorial obligations. In other words, the obligations that states have beyond their territory. So the easy example that came up in the US when hearings were held under the Carter administration on this economic and social rights covenant, there were people, I think Phyllis Schlafly was one, well-known feminist, who came in and said, my God, if we ratify this covenant, next thing we'll be obligated, and I'm paraphrasing here, obligated to feed Bangladesh, if you get the message. In other words, if we accept that there are economic and social rights, if we accept that there are some international obligations that attach to them, we as a rich country will immediately be obligated to bail out the poorest countries, those that can't feed themselves, etc. And so there's been a lot of work done recently, books and statements of principles coming out on extraterritorial obligations. They are particularly significant and useful, I think, insofar as they relate to corporations and the attempt to try to impose some sort of corporate responsibility beyond the borders of the home state. But I have to say that when it comes to positing formal international obligations on states, we aren't going anywhere. And I say that with regret, but again, I think some sort of realism in terms of coming up with an agenda is indispensable. When I say we're not going anywhere, there are a great many important philosophical works that have been written, for example, international distributive justice, cosmopolitan approaches to rights, to resource distribution, and so on. Many impressive cases have been made as to why there should be some forms of global sharing, why states, why peoples who are deprived of minimum levels of subsistence should be able to count as a matter of entitlement upon contributions from those of us who have more than we need. I'm all in favour of those analyses, but states are not. No state has taken up these issues, and I don't believe any state is likely to. We have translated them into discussions about the percentage of GNP that should be devoted to official development assistance, etc. That's a debate that's been going on for a good many years, since the 1960s. I think the target was first identified. There have been international commissions endlessly. Some of you will be old enough to have heard of the Brandt Commission. Willy Brandt, former Chancellor of Germany, set up the so-called North-South Commission. It was all about this stuff that unless the North is fully supportive of the South, there will never be peace on earth, and certainly there will never be respect for human rights. Again, I totally endorse those sentiments, but as a practical matter, there has been no movement internationally to show that governments are prepared to accept obligations to provide international assistance such that economic and social rights deficits in the most needy and deserving countries would be eliminated, would be dealt with. So what I want to argue then, coming to a more positive dimension, is to say that there is a single issue, or two issues combined, that could do more to promote economic and social rights than any of these efforts to achieve some sort of international redistribution. They are quite simple, and they are known, but we've done very little about them. They are resource transparency and anti-corruption. Now, sounds fairly simplistic. There are efforts, there are international groups that are dedicated to trying to enhance the degree of transparency about financial transactions that governments engage in. These are most obviously important in terms of natural resource-rich developing countries that receive large amounts of money from mining companies, oil companies, etc. But the amounts involved are never divulged, never by the oil companies, by the other mining companies, never by the governments themselves. And the great majority of those resources disappear without trace. This was one of the biggest problems that I encountered. This is, I don't want to take too much of a diversionary path, but Hope mentioned that when I was working on extrajudicial executions issues around the world, I engaged, for example, the US on targeted killings and the use of drones in certain circumstances. That was really, that was one of the most high-profile issues. Nothing irritated the US government more, and so on, so it was fun to do. But it was peanuts compared to the real work that I was trying to do. The real work was in countries like Kenya, Nigeria, a range of others, I'll spare the list, where the whole system was so rotten from corruption that everything came back to it, that so many of the killings came from the policeman who said quite openly, and his superiors said, I'm paid pennies. I can't live on what I earn. If I don't set up the roadblock outside in Forsyth Street and charge every car that comes down $1, my family's going to die. I've got to do it. And of course, many people were killed at those roadblocks. Where's your dollar? I don't have $1. You bastard, you either hand it over or you're in trouble. Guy sort of struggles and cop pulls his gun and shoots him. That was just the beginning, because the cop who's picking up $1 per car on Forsyth Street goes back to the local station. Don't know where it is around here, but... And the captain says, so, Philip, what was the take today? And I've got to come clean. I've got to give him his, whatever it is. Might be 50%, it might be more. If I don't, I will either be fired or I will never again get the prime location on Forsyth Street. Corruption is endemic all the way up. And the big question for me was, how the hell can you look at these countries where the police are in fact a force almost exclusively for evil because of the corruption dimension? How can one resolve that? What's the point of saying, well, you need better accountability mechanisms, my friend. Why don't you set up a commission for police integrity? At which point the cynical politicians say, oh, gosh, good idea. Yes, I'll get my good friend, corrupt Captain Smith, to head up the Police Integrity Agency. And so, but the issues of corruption are not really on the human rights agenda, at least front and centre. They are tangential. It's someone else's work. They should, in fact, be seen as one of the central issues in the human rights field as a whole, and the absolutely essential issue in economic and social rights. The big issue in economic and social rights is the availability of resources. Who's going to pay? How could we possibly educate all our children? How could we possibly provide even minimal health care for everyone? And the answer, of course, is that if the money wasn't flowing into the Swiss and other bank accounts of the rulers of these countries, Central African Republic, if you're following what's going on there, a coup, a very mineral-rich country, no money in the resources, in the coffers, nothing. And yet it's got huge wealth. If corruption could be stopped, it would be a rich country. Small population, huge potential. So I just want to say that I think that much of the time and effort that has been spent on talking about international redistribution could much more profitably be spent on integrating fully a major anti-corruption effort into a social rights agenda. Next, one of the big problems in at the international level, but also at the domestic level, is sectoral, I suppose to use the in-term, siloing. In other words, you have NGOs dealing with housing rights, NGOs dealing with food rights, NGOs dealing with education rights, and more importantly, in a way, NGOs dealing with labour rights and with social security. And very rarely do they come together. There are a few exceptions. There's NESRI, the National Economic and Social Rights Initiative here in the US. There's the Center for Economic and Social Rights. There's Economic and Social Rights Net. For the most part, these issues are seen very separately. And that is also repeated in the UN context, where different agencies do their own things. And of course, they don't pick up on what some other agency has done. So the single initiative that I think is the most significant and important of recent years, but has got almost no attention, is a proposal by a group of agencies, the ILO, International Labour Organization, World Health Organization, I think UN Women, but at least Michelle Bachelet, its head, perhaps in an earlier incarnation, that there should be a social protection floor introduced in every country. It is a form of social security, but it's a rather qualified one that has in fact been successfully promoted in recent years in countries like Brazil, Mexico, and a number of others, and has enormous potential. Instead of focusing on the silos, how to get kids into school, how to get nutrition for mothers and children and so on, the social protection floor is a sort of comprehensive scheme that includes, of course, fiscal dimensions, which are so often neglected. It's not simply a handout, it's linked to tax arrangements and so on, but it has immense potential. It seems to me unlikely to be taken up, in fact. It's recently been endorsed by the International Labour Organization Conference last year, 2012. That will stamp it in the eyes of the international community as an ILO initiative, something that workers might be interested in. It hasn't been taken up by those of us advocating and promoting economic and social rights. And yet it seems to me to be an initiative with immense potential. Finally, well, actually two other comments. One of the major problems in relation to economic and social rights has been an inadequate attention to what national groups can do, what local groups can do. There's been too much attention by people like me, international lawyers, who focus inevitably on the international area. What can the world do? What can different international organizations do? And not nearly enough attention on building some sort of grassroots economic and social rights movement. Human rights are a very strange combination of top-down and bottom-up. They are top-down in many ways. They were declared by the UN in 1948. They are often foisted upon countries. You know, Cambodia comes out of the genocide, gets a sort of UN-supported regime, and overnight ratifies 20 UN conventions. It's not because the Cambodians had a fundamental change of heart. It was sort of foisted upon them. But over time, that can work. It's not to say that it's a bad thing, but there has to be the bottom-up dimension as well. It cannot just be top-down. It doesn't work. Economic and social rights, there's huge potential for bottom-up work which really adopts notions of economic and social rights, but it generally hasn't taken place. One of the key culprits, foundations. If you look at the human rights movement around the world today, I've not done this, but nor have I seen a study on it, I think you would be able to trace an awful lot of the successful activism back to the Ford Foundation or some of the other major foundations. That very consistent, or back to the CIA, if you like, as well, which in earlier decades was a very important source of funding for many early human rights groups like the International Commission of Jurists. There is no equivalent in relation to economic and social rights. Most of the foundations continue to be reluctant to fund in this area, and that in turn means that those who are active on the ground, who are influenced by where the money is, they need $5,000. They're not going to get it locally. They will get it internationally. But if the foundations don't make it available for economic and social rights initiatives, it makes a very big difference. I think the rest of us also needs to focus, however, much more at the national level. I think national human rights institutions, which exist, human rights commissions in many countries, do all too little on economic and social rights. Again, we continue to look at them and expect them to do civil and political rights work and ignore the fact that they're only looking at half of the overall agenda. Similarly, the UN committee that I started off talking about needs to do much more to focus on how it can empower, how it can catalyse, how it can get local actors, including governments and others, to do more about economic and social rights. It hasn't done that. I could talk much more about that, but I don't have the time here and now. And the final point I want to mention, the most neglected single issue in relation to economic and social rights, this applies, of course, in relation to the US, but to all countries, is simply the issue of taxation. Most economic and social rights proponents do very little about taxation. But you know, I'm sure, from looking at the system we have in this country, that the real economic and social rights decisions are made in the tax debates. That's where it happens. That's why the Republicans are saying now we will not look at the various exemptions and so on that are built in, because those exemptions benefit immensely the wealthy and benefit very, very, very little the poor. But that is true in a great many countries where the real welfare that's handed out is through the tax system. And yet there are very few studies of taxation linked to economic and social rights. The issue has simply proven too hard for us. I plead guilty myself. NYU has a very extensive tax program. I've got a number of great colleagues, and a number of them are very socially aware, socially conscious I've never had discussions with them. I will, I promise. I threaten that to them. But I think it is a frontier that we have to embrace. Economic and social rights proponents have to start systematically examining taxation arrangements in all countries around the world, and it will take the agenda very much further. I'm going to leave it at that. I hope I have outlined a number of issues where the UN has made a contribution, where it's not yet doing enough, but also identified areas where those of us concerned with these issues should be focusing more of our attention than we have so far. Thank you.
My name is Ajulo. I'm a second-year student here. I wanted to follow up on your comment about corruption and get a sense from you about what the solutions to that problem might be. You mentioned the low pay of civil servants. Are there other things that come to mind?
Yes, my prescriptions would not be at the micro level, as you suggest. I mean, I think that's absolutely right. I think questions of salaries are very important, certainly for police. Police around the world are generally gravely underpaid. As some of you will know, Singapore, for example, pays its cabinet ministers, of whom there are quite a few, several $1 million a year, each cabinet minister. And the argument is simply that they will not be very easily corrupted if they have no problems with money. Seems to me to make a lot of sense if you can afford it. But what I'm much more interested in is international efforts. The reality is that the international community has colluded in corruption comprehensively for many years. There has been a very long-standing resistance to interfering in any way with international financial flows. We proved dramatically that we can do that if we want to in the aftermath of 9/11. Suddenly the whole terrorist financing efforts were able to probe into areas that had previously been utterly off the agenda. You couldn't touch them. Private bank accounts we're not going to scrutinize, etc. We still don't do that. Cyprus, sorry to reduce these things to fairly simplistic analyses, but that's what one has to do in giving a two-sentence answer. Cyprus is about corruption that hasn't been tackled. The money flowing in from Russia and elsewhere, the dirty money that no one wanted to, that's being laundered. Everyone knows it was being laundered. The tragedy now is that Cyprus has grown totally dependent on all that money laundering, and the new arrangements that have been put in place threaten to remove its lifeblood, corruption. But even the EU wasn't prepared to be proactively tackling that. And yet again, the people of Russia are the ones who are being screwed by these billions coming out in the name of all the oligarchs. So if there was a more sustained international anti-corruption effort, there are efforts. The World Bank has a corruption program and so on, but it's peanuts compared to where it could be if this was really taken up. The problem is that as soon as you get heads of state in a single room, half of the heads of state are on their cell phones checking their private bank accounts in other countries, and they ain't going to be going down this road. That's why it requires public pressure. It requires a major public movement, which starts with what I said was transparency of resource payments, etc. I guess it's a question of sectoral responsibility, to use the term I used earlier. In other words, the initial reaction of human rights proponents would be, very interesting issue, but you've come to the wrong person. I don't do corruption. That's my colleague down the road who does, I don't know, OECD concerns or World Bank or whatever. It's not human rights. And all I'm saying is that it is so central to human rights, particularly, but not only economic and social rights, that we as human rights proponents have to make a major contribution. The sort of reporting, the naming and shaming, which is used so often in relation to torture or other governmental abuses, isn't happening on corruption for the most part. No, the Equatorial Guinea, some of you may know the story, Equatorial Guinea is worthy of a movie. It should be a bestseller. The levels of corruption are absolutely stunning. The levels of poverty in one of the richest countries in Africa are equally stunning. But, there's an occasional story in the New York Times. There's an occasional NGO report, but it ain't a major issue. Those sort of things there should be real campaigning done around the extent of and the nature of corruption and its implications for human rights. Right.
Hi, I'm Leo Blitzky. I'm a faculty here, and I work a lot on issues of police accountability in international settings, so what you said really rings true. And I wonder, actually following up on the point that was made before, whether there's an opportunity to engage with the more business-oriented interests in forming partnerships to tackle corruption, because at least the theory is that you need robust rule of law to conduct business transactions, and does this present an opportunity? And in practice, I think the real kind of private public partnership in that area has been really weak. But do you have ideas for whether there's more of a potential?
No, I think that's a very good point. When I reflect on why businesses haven't been more active, I guess there are two easy explanations. One is simply the market takes account of this, and if corruption reaches a certain point, companies just don't invest any longer in that sector or that country. Or, of course, they go to the dark side and they realize that in order to do business they simply have to make corrupt payments, which they do. And the other element, of course, is that in many areas where companies have no choice but to operate in countries that are deeply corrupted, they, of course, have their own private security. They completely privatize it. They actually want nothing to do with the local police force. If they are compelled to, as in Nigeria, they will then pay or Indonesia or whatever, they'll pay the salaries of the police and buy them off that way and buy some sort of... So basically they're not addressing the society-wide problems, they're just taking care of their own immediate needs. But I agree with you that it's a big issue that could be taken up on a more aggregated basis by corporate actors.
Okay. Thank you very much, Hope. Valerie Gordon was one of our Black Law Student Association students, and she epitomized the think globally, act locally ethic of human rights work. Just a few other words about her. She graduated after being told that she would not get anything more than a C from Michigan University premier journalism school, our first journalism school in the country. She came to Northeastern and she fought for faculty of color to be here. She, with the Student of Color Coalition, staged a walkout that resulted in your Legal Skills and Social Context program. And she made sure that the BALSA students had the name Kemet Chapter, which means Black people, as the name of the organization. We're the only BALSA chapter that has its own African name. So, so that is the spirit of Valerie Gordon that is with us. If you look on your front of your program, you will see her compelling image, very tastefully done, on the front of your program. Each year, BALSA runs a competition for the spirit of Valerie Gordon. And that competition is to write a piece on international human rights as they affect the African diaspora. And this year, Mayumi Grigsby wrote a wonderful piece called Enforcing Economic, Social, and Cultural Rights, a Stark Dichotomy. And we're going to ask her, if you would bear with us for perhaps 5 minutes, we're going to ask her to read an excerpt of her article that she wrote.
Thank you. I was going to thank a lot of people, but I'm going to delve into my piece directly. But I should say thank you to Professor Susan Mays Rothstein for taking a 7-page paper that was essentially a manifesto of my feelings and thoughts and turning it into an actual legal argument. So this is the excerpt. Two very similar circumstances, two very different outcomes, occurred in two very different parts of the world. On April 20th, 2010, an oil rig in the Gulf of Mexico burst into flames, dumping millions of barrels of oil into the Gulf. 11 people were killed, and irreparable damage was done to the environment, fishing, tourism, and local economies. Following the explosion and the resulting massive oil spill and cleanup effort, hundreds of plaintiffs filed suits asserting personal injury, economic loss, and property damage. Some of those suits were centralized, and approval was given to a proposed class action settlement of medical claims arising out of the spill and the cleanup effort, amounting to approximately $7.8 billion United States dollars. The Ogoni people, under similar circumstances, have not been so fortunate. The Ogoni people are an ethnic group residing in the Niger Delta in Nigeria. Oil was discovered on land belonging to the Ogoni in 1957. In 1959, Royal Dutch Shell and Chevron Corporation began production of crude oil on the land. The methods used by the corporations during production were careless and led to the environmental degradation of the Ogoni people's homeland. The Ogoni alleged that the operations of these companies included disposing of toxic waste into the environment and local waterways, failing to maintain its facilities, causing numerous avoidable spills in close proximity to villages, and leading to the contamination of water, soil, and air. Protests against the oil exploitation and the environmental destruction led to violent clashes with police and forced evictions of entire villages and communities. There are allegations that the Nigerian military commenced raids on villages, which led to human rights violations, including displacement and death. Although Shell withdrew from Ogoni land in 1993, the Ogoni people have maintained that Shell was complicit in the violation of their economic, social, and cultural rights, hereinafter ESC rights. The Ogoni people further allege that Shell was assisted in these violations by the Nigerian military at the time. For communities residing on the U.S. coast of the Gulf of Mexico, the oil rig explosion resulted in a diminution of certain rights, including the right to an adequate standard of living. Fishermen and other groups relying on the contaminated water were severely and negatively impacted. The United States has not ratified the international treaty designated to define and uphold ESC rights. Fortunately, some communities affected by the British petroleum oil spill were able to obtain some form of restitution, although there are still cases pending at the state and federal level. In a stark dichotomy, many of the Ogoni people, citizens of Nigeria, still await justice for the violation of their ESC rights. Like the communities in the Gulf of Mexico, their right to an adequate standard of living, in addition to their rights to housing, food, and water, also referenced in Article 11 of the International Covenant on Economic, Social, and Cultural Rights, hereinafter the ICESCR, were violated by non-state actors. Article 2 of the ICESCR describes the nature of the general legal obligations undertaken by states party to it. Article 2 requires states that are party to the ICESCR to take steps with a view towards, quote, achieving progressively the full realization of the rights recognized in the present covenant by all appropriate means, end quote. Article 2, in spite of its encouragement towards, quote, progressively achieving, end quote, obliges a state party to take the necessary steps to the maximum of its available resources. It would be difficult to argue that Nigeria, as a matter of state policy, is striving for progressive implementation subject to the available means at the disposal of the state to provide the services, facilities, or support required for their meaningful enjoyment. Nigeria is considered a lower middle income country with a significant dependence on oil revenues. In fact, oil represents 80% of the Nigerian government's revenue. In spite of being an oil-rich country, Nigeria faces many challenges including poverty, 54% of the population remains in poverty, income inequality, approximately 20% of the population owns 65% of the national wealth, a high prevalence of HIV/AIDS. Nigeria bears nearly 10% of the global burden of HIV. Approximately 3.3 million live with HIV/AIDS out of the 158 million population, and gender inequality, which leads to high unemployment and lack of access to health care for women. On December 18, 1996, the Commission on Human Rights implemented an optional protocol for the ICESCR. The protocol granted the right of individuals or groups to submit communications concerning non-compliance of a state with the ICESCR. Unfortunately, to date, only 10 countries have ratified the protocol. The protocol will still go into effect even with the ratification of only 10 countries, giving the Committee on Economic, Social, and Cultural Rights, hereinafter the CESCR, for the first time competence to hear those individual complaints. The Ogoni situation, assessing Nigeria's compliance with Article 2. Nigeria's legal system is based on the common law that coexists with traditional or indigenous customary laws and Sharia law. Nigeria is a federal republic, and the basic law is derived from the 1999 Constitution, which was amended in 2010. Nigeria ratified the ICESCR on July 29, 1993. It entered into force in Nigeria on October 29, 1993. Nigeria has neither signed nor ratified the optional protocol. Nigeria's oil-based economy is linked to the plight of and deprivation of ESC rights to the Ogoni people. Prior to 2001, there was an unsuccessful attempt by the CESCR to address the breach of the Ogoni's Article 2 ESC rights in its own sessions, and those procedural events may have led to several cases, specifically a 2001 case against the Nigerian government. In 1996, just 3 years after the Shell Oil Company left Ogoni land, the CESCR submitted a list of issues to the Nigerian government regarding its noncompliance with its obligations in the ICESCR. The CESCR expressed concern about the Nigerian government's violation of the ESC rights of the Ogoni people. The later appearance of the same allegations in the 2001 complaint with the African Commission under the African Charter demonstrates the challenges faced by the CESCR in ensuring that states follow their obligations as detailed in Article 2. Recently, in December of 2012, the Economic Community of West African States found that the Nigerian government had violated the ESC rights, including the rights to food, to work, to health, to water, to life and human dignity, to a clean and healthy environment, and to economic and social development of communities residing in the Niger Delta, where the Ogoni and Bodo people reside. The accumulation of judgments, while individuals continue to wait for restitution, illuminates the challenges faced when attempting to uphold and protect ESC rights in states that are party to the ICESCR but who have not signed its subsequent protocol. With only 10 countries signed to the protocol so far, there are significant challenges in enforcing Article 2. A few have looked outside of the confines of the ICESCR and Nigeria to find restitution on ESC rights violations, using novel approaches to established legal theories. Some approaches have challenged the validity of ESC rights as customary international law. The argument could be made that the rights within the ICESCR are specific, with 160 countries signed on to and bound by the ICESCR, that ESC rights contained within the covenant are both universal and obligatory. This would possibly elevate the ensuring of ESC rights and the protections contained in Article 2 to the level of customary international law. Under that theory, any state that grants jurisdiction would be able to provide a path to restitution. The plight of the Ogoni in their quest for justice began in 1959 when their ESC rights were violated. The Ogoni have used a plethora of methods to attain restitution. The ideal result would be to have more countries ratify the protocol, allowing the ICESCR to have a mechanism with which to hold states parties to the ICESCR accountable to its obligations in Article 2. In the meantime, the Ogoni people and others like them continue to seek justice and vindication of their ESC rights in their home country of Nigeria and abroad through inventive legal arguments. The United Nations Environmental Programs provided a report in 2011 claiming that the Ogoni land would need the world's largest ever oil cleanup, which could take up to 30 years to be completed. Thank you.
Thank you, everyone. For those of you who don't know me, my name is Tiffany Malcolm. I'm the co-chair of the Black Law Student Association. And on behalf of BALSA and the entire Northeastern community, it is my pleasure to award Ms. Mayumi Grigsby with the 2013 Spirit of Valerie Gordon Book Award.
Thank you.